SJC-13357, Commonwealth v. Jeffrey A. Souza.
Attorney Souza, whenever you're ready.
Good morning. Chief Justice and Associate Justices, may it please the court, Matthew Soares for Jeffrey Souza. I would like to address issues 1 and 2, but of course I'm happy to take any of your questions. The first issue is that the trial judge erred when she cut off the testimony of the adjutant witnesses as soon as they had testified to the first blow of the violent incident. And this error went to the heart of the defense because it prevented the defense from presenting the truth about the decedent, Kyle Brady, that he was a powerful force that could not be stopped. That was the center of the defense. That was the main theme of the
You're
defense.
asking for a change in the law, right?
I'm for the second issue. I am which addresses the jury instructions for self-defense. I believe that it could be improved. As far as in this particular case, the judge did not even follow the model instructions. She added another sentence, and that made it.
Can you tell me first what the improvement is that you think is appropriate?
Sure. Well, for one thing, it's ambiguous as to.
But what would you have it say?
I would have it be clarified that when they say for the purpose of determining who attacked whom with deadly force, and to first say that there's two types of force. There's two questions to be decided: who first initiated the conflict, and who escalated the conflict by first use of deadly force. The way it is now, it just says who attacked whom first, and then it talks about deadly force. It would need to say specifically.
I thought what Chambers said was don't read adjutant narrowly, because Judge Quinlan in the Chambers case said, well, I can't do this because they were involved in a non-deadly fight. The defendant started the non-deadly fight, and then there was deadly force, and we said in Chambers, well, don't read that. Instigate also include, who started it with deadly force, who escalated it essentially.
Yes, Your Honor.
And then the model instructions in 2018 cite heavily to Chambers as well.
Well, it doesn't.
And it cites in Chambers, it cites approvingly to the 2013 instructions.
In Chambers.
Yeah.
Well, it doesn't, the change in the instruction doesn't say anything about the two types of deadly force.
Well, the note to the judge in 2018 says, and it uses the Chambers hypothetical. It says, hey, judges, in appropriate cases, add the following instruction if someone uses force. But it says, but if you escalate a simple fist fight into a knife fight, which is Chambers, then
Right.
you get the instruction as well. But it's still relevant to who started it.
Right,
But you want deadly force to be used in the instruction.
It needs to be clarified that the adjutant evidence can go to both types of.
But wouldn't the
both
judge
issues.
make that threshold finding? So basically a judge, which Judge Quinlan was misled, not misled. She did what the law required, but she didn't expand adjutant. But it's the question of whether or not this evidence is admissible at all. So if a judge said it's not admissible, it just doesn't come in. And then if it comes in, then it has to do with who started the fight.
She said it was not admissible as to.
Right, because there wasn't a question of first aggressor as far as the fist fight, not the knife fight.
Well, they didn't really get into that so much. She just said, well, the question is who first.
But you've won that. So Chambers is Chambers, and Judge.
Right. And the other-
Garsh, in this case, said, okay, I'm going to give you adjutant evidence and allowed in the 3 incidences in this case. You think that, and there's some language in Chambers that supports you, you think that it should be beyond first aggressor. It should be basically, was it reasonable to use self-defense because give them everything
Yes.
in this fight?
That's the second part of the second issue. As that Chambers says, it wasn't just admitted for the question of who was the first to use deadly force or who was the first. It's for the general overall purpose of proving if the defendant
I
has.
think that language supports your argument.
Yes, I agree, Your Honor, and that there's nothing about that in the judge's instructions here.
There's a little bit of a lack of clarity on this, though, and I'd like to see if you could help us out. There's 2 different issues. One is the relevance of adjutant-type evidence as it relates to who is the first aggressor and whether you get the entire incident to be able to help the jury determine who the first aggressor is based on propensity inferences. But then there's the other issue, which is, does adjutant apply to all of self-defense or just to who is the first aggressor? And those issues are sort of mushed up
Right.
in your brief and in this case. So are you saying both? Are you saying just one?
Well, I'd like to differentiate between the first issue in my brief, which is fully preserved, and that the judge in this case, without going into other cases at all, the judge in this case erred, and it's a preserved issue, so it's harmless error.
So that's the first issue.
That's the
To
first
extent
issue.
there's any confusion, the first issue that's preserved is that Judge Garsh said, in determining who the first aggressor is, the only relevance of the prior act of violence is who initiated the violence. And you're saying, no, we need the whole incident to be able to determine who the first.
Well, I'm saying first in that issue that she limited it in this case, and she just said it's limited to the first blow.
Right.
I don't see any support for that in any authority anywhere.
Well, adjutant says, give them as much as you need to be relevant to who struck the first blow. It's a relevance determination, as Justice Lowy said, in an abuse of discretion standard thereafter. I think the problem that we had applying adjutant in the trial court was sometimes lawyers wanted to submit a conviction, and they say, here you go, the person was convicted, the victim was convicted of assault and battery. And I think a lot of judges said, well, that doesn't tell the jury anything. It doesn't illuminate the
Yes, Your Honor.
facts. So
Right.
so Mr. Defense Attorney and Ms. Defense Attorney, get yourself a witness, which was the issue. So, but you did that.
Yes,
And
the trial
you-
counsel.
trial counsel did that and appropriately
Yes, and they had a
introduced the
discussion.
evidence. And now it's Judge Garsh's decision, and I think she said, we don't want a trial within trial. I'm going to stop it at some
Well,
point.
before she even gets to that, she says that this was not adjutant, so that's prior conduct showing propensity.
No, she said the latter part was an adjutant. She allowed the incidences, the bar fights. And
She
then
just allowed the first blow.
Right.
And that is almost nothing of these
But
incidents.
doesn't that show who initiated the fight, the first blow?
Well, who initiated the fight? It shows that he initiated the fight, but it doesn't. The question is not who initiated the fight. All the evidence goes to that of the incident because it shows the power of him. He's more likely to initiate the fight.
That's your second argument, right? Because that more goes to that language in Chambers as to it's relevant to everything.
Well, it's the first argument in that there's nothing that says, it says violent incidents, evidence of violent incidents. It doesn't say the first blow of the violent incident.
See, that's what I was saying in my question. It's mushed all together, and you need to differentiate between the 2 principles that are going on here, because as you point out in your brief, Judge Garsh under adjutant has enormous discretion, but if she doesn't know she has the discretion,
Right.
then she doesn't get the protection of the abuse of discretion.
This is not an abuse of discretion.
So, again, there's two issues. One is when you're looking at adjutant evidence, and who's the first aggressor? Is the evidence only admissible who struck the first blow in the prior act? And you're saying no.
No.
And then the other issue is, does adjutant evidence include all of self-defense, retreat, violence being reasonable in these circumstances? And I think you got to differentiate between those.
That is a further.
Help us understand what we're doing.
I agree that's a further issue down the line, but we don't even need to. The judge erred just under adjutant. Forget Chambers that comes in and says, it clarifies, in my opinion, adjutant saying it's not just for the purpose of first aggressor. But she limits evidence so much that even if Chambers never existed, she erred.
I think that's a tough argument for you. I think that the Chambers language helps you, but I think
Oh, it definitely helps. It helps very much. But I think just under adjutant, she erred. I looked.
you might want to
everywhere.
move to the second issue because your time's going to run out.
Okay, the jury question, yes, and the one thing you put out the amicus call, and in this case, the judge, it's different than the model. She added a sentence saying it's limited to that only. So that's not even in the model instructions. She didn't even follow the model instructions there. So that's a major problem with her instruction. And then the other issues are how can you tell what first aggressor means? For the purpose of determining who attacked whom, well, does that mean started the fight or first to escalate with deadly force?
Deadly force case, what's the prejudice?
Prejudice is that Chambers says this, that there's two issues, and if it's in dispute, the evidence is allowed to determine both issues. It's not decided here who started the fight. Nothing's decided here. That's why this was not harmless error at all. This case is less clear than adjutant, less clear than
Do you think
Lynch.
Chambers would allow an entire incident in, and then the defense attorney would be able to argue this was reasonable self-defense because look at the pummeling that this person gave to the cop and to the people in the bar, basically.
Right, he's a force that can't be stopped. And
So that equals reasonable self-defense because of the nature of his violence,
right,
the propensity for his propensity for violence.
right, and the Commonwealth's arguing two different things in the first issue. They're saying, well, it only matters it doesn't matter they cut it off at the first blow, but that doesn't show deadly force. In the second issue, they're saying, well, it doesn't even matter who started the fight, it's deadly force, that's the issue. Well,
How hard would it be, or easy would it be for a jury to identify when the precise moment of deadly force begins?
it's not very easy at all. That's one reason why
So
you
the
need to
error,
put in as much evidence as possible of not possible, but evidence that's non-cumulative, evidence that's relevant. These incidents are completely that, and the judge determined before they had a pretrial hearing. She said, yes, this comes in, these incidents are fine. And she just said, no, it's only the first blow. I don't know where she got that.
Can you clarify this for me? The error in her instruction is the last line where she
Right,
said
yes.
you cannot consider such evidence for any other purpose whatsoever.
Yes, she said that
That was
every-
added, and that's the error in
She
your view.
said that every time for all the three adjutant witnesses and the
But
two
that's
Morales.
your allegation of error.
That's part of it. That's,
But the instructional error.
yeah, she added to that. That's her own error added to, and I think the instructions,
But the instructions you have to concede were written with Chambers and all that Chambers language in mind, because it cites Chambers.
it cites Chambers, but it doesn't say what Chambers says about the evidence is admitted for the overall purpose of determining self-defense. It
No,
segregates it within the fifth
Agreed,
proposition.
agreed, and might be silenced by, you might be doomed by the failure to say that. But yeah, it does not say that.
Right, and it also is unclear, it doesn't have a dual definition of first aggressor.
You recognize this would be a great expansion of adjutant?
I don't think that it would be. I think that under the first issue, not at all. She just completely got that wrong. But you're talking about the second issue if you were to revise. Chambers does say that that's not an adjutant, yes. So is Chambers.
Yeah, we have to take those two lines from Chambers and say,
Right.
what we said, even though Chambers has an adjutant sandwich, it says first aggressor, and then it has that language
Right.
in
Right,
the
and I
front.
agree that language in Chambers is not an adjutant, and it's ambiguous, as we point out in the brief,
But
so.
can I ask the same question Chief Justice Budd started with, which is, are you expanding the whole concept to this? Once he starts a fight, he's going to escalate it no matter I mean, it seems like you're basically saying that he's going to use deadly force no matter what, because he just will keep fighting. That's different, isn't it? That's a whole nother concept. Basically, this guy's so violent that unless you kill him, he's going to use deadly force.
Well, in
that
this
sort of what
case,
you're
it's for the
saying?
jury, it's a jury question to decide.
But that's not adjutant, is it? That's a new concept, right?
I don't believe it's a new concept. Adjutant says that it's propensity evidence, propensity for violence. And to cut off it at the first blow, he started a fight with somebody. The important thing is that lots of people start fights. This guy finishes them and wins them. And he's reckless, and the defendants said that he ignored a warning shot and just ran at them. And all they get is that this guy started a couple fights. They don't get that he had to have multiple officers bring him to the station. He was tased 6 times, didn't go down. That's the point, that was not presented to the jury at all. Sorry, I'm over time. If there's anything else.
Okay, thank you.
Thank you very much, Your Honors.
Okay, Attorney Nathanson. I'm sorry, Nadeau, I apologize.
No problem. Thank you, Madam Chief Justice. Good morning. May it please the court. I'm Stephen Nadeau on behalf of the Commonwealth. Our position, of course, is that the trial judge appropriately applied adjutant in Chambers when she admitted and then curtailed some of the prior violent acts initiated by the victim in this case, and when she instructed the jury on how they were to use the evidence.
Mr. Nadeau, how do you get around the Chambers language on page 529? It says that it's not limited to this purpose. It was admitted for a broader purpose and given the jury relevant information regarding the victim's prior act of violence that may help them evaluate conflicting evidence as to truth regarding the events that led to the victim's death and ultimately determine whether or not the prosecution met its burden of proof. So it talks about adjutant in Chambers and talks about the initiation of violence and says violence is going to be who initiated the knife fight too, not the fist fight. But then it has that line I just read about the broader purpose. And I think that supports what counsel was just arguing, that, well, maybe we should take a look at this because we said in Chambers it's broader purpose, not just first aggressor.
Right.
Response.
So,
You better get a drink of water.
I need it. Thank you. So my response is, first, unfortunately, I kind of can't make necessarily heads or tails of that paragraph, given that it's sort of predicated on a mistake, I guess, about what was introduced in adjutant and Chambers. And certainly it's, I think, within this court's power to have expanded adjutant as expansively as that language would do. But I don't think that's what the court intended to do there. I think, as I note in the brief, that it was just a reference that this is not only why some of this evidence might come in, there may be other issues. And also as kind of reminders, there's some other language in Chambers, just, where Chambers was kind of novel because it dealt with the first aggressor issue. It was sort of instructing trial judges, as you mentioned, don't read these things hyper-critically or hyper-technically. Give some flexibility for the defendant who's accused of often very serious crimes, who may need to creatively introduce evidence as part of his defense. I would also refer to Commonwealth versus Camacho, which is cited in the defendant's brief. at 472 Mass 587. And that comes after Chambers and is an example of the court kind of drawing a very clear boundary around what the relevance of this kind of evidence is. And I'll just read briefly from a paragraph there. Given this largely undisputed evidence, the primary question for the jury was not who began the altercation or escalated to deadly force, but rather whether the defendant was legally entitled to use the force he did in defense of another. There may be a question as to which act, the bottle throwing or the gun firing, escalated the fight into a deadly confrontation, but that is a wholly distinct issue from the individual who initiated which act.
And we had DeConnick as well, so we've never returned to this Chambers language. Is that the point?
Certainly not
This broad
as
Chambers
a
language.
basis of a holding or anything like that. It was expanding beyond.
But counsel, if you could, I still don't know if you've actually gotten to Justice Gaziano's point. I'd like to follow up, if I could, about Chambers. So one of the concerns that that I think is being brought up here is this larger picture. And, you know, you just mentioned the language in Camacho about whether or not the person was legally entitled to do what they did. And so that brings up the reasonableness of what they did, right?
Right.
So if you don't have the larger picture, and I'm going to separate this out for you for a second, not that all of these things would come the more fuller picture of what the person has done in the past, to give to the jury, or perhaps have the jury use it to engage in propensity reasoning. It's that the defendant engaged in propensity reasoning because it was the defendant's reasonableness of their actions which is informed by what I thought this person was capable of. And that is a function of telling them what he's done before, to gauge the reasonableness of what the defendant did, how they reacted. So when you look at the language in Chambers, wouldn't that be relevant to the reasonableness of the fear when it comes to what they then did?
Well, these kind of acts are admissible when there's evidence that the defendant knew of them.
Sure.
If he doesn't, it may not have any effect on how he would respond if he doesn't know about those.
This is just as Cowan said in adjutant, this is pure propensity, because Fonts and Pidge were the defendant knows,
Right.
right? So,
Yes.
but this is just whether or not we're looking at propensities, and I think the point that we're making, and Justice George is making as well, is that isn't it basically more fair that if we're going to go down this road, that the jury be informed of the totality of what the defendant or the victim is capable of?
Yes, and I think in the circumstances of this case, there was ample evidence of the victim's propensity.
But you have the judge's instruction, which went beyond our model instructions, said don't use it for any other purpose.
Yes, and I think that was consistent with Camacho. I sort of imagine that's where Judge Garsh got that line from. But again, in the circumstances of this case where the violent acts, the victim directly threatened to visit upon the defendant in this case, the defendant testified to reputation. It was essentially undisputed that the victim was a violent guy.
That's the prejudice issue. We're still trying to get our arms around the first issue, the preserved issue, which is whether or not on the issue of who is the first aggressor, the jury can consider more than who struck the first blow, but can consider the entire incident in order to help determine who is the first aggressor. Right. And that issue, remind me if I'm wrong, that issue is preserved.
Yes.
And it's not, and we're not analyzing it as to whether Judge Garsh in her wide discretion under adjutant, because there is wide discretion for trial judges under adjutant. We're not determining whether Judge Garsh looked at the situation and said, no, these fights, I'm only letting in the first blows. She thought that's all she could let in. So she doesn't we don't look at whether or not it was appropriate exercise of discretion.
Well, I think actually Judge Garst was not using a, hyper-technical application of adjutant. I think this case and her approach to it kind of shows the flexibility of adjutant in chambers, because in all three of the acts that were introduced, they were violent acts already in progress when the witnesses, all police officers, showed up on the scene.
That's not how I looked at it. I mean, and I'm happy to be corrected about how it came in. I thought what she was saying, no, you're not getting into these events beyond the first blow.
Right.
And well, certainly in some of them, the evidence went beyond the first blow. So it's not like she struck, the evidence, for instance, at the Almac Steiner, where, there's a fight and then it continues as they fall to the ground and it goes on from there. So no, I don't think adjutant requires exclusion of evidence after the first blow, and I don't think that's what Judge Garsh.
You don't think that's what she did?
No. And I think her expressed concern was about the creating trials within trials.
Which goes to her discretion, really.
Right. And I think her saying that's not adjutant was kind of just a shorthand way of saying we're going beyond the relevance here and getting into, again, trials within trials, cumulative and prejudicial evidence.
And how does that square with her subsequent instruction as to how the jury could use the evidence that came in from the officers?
I think that was an appropriate instruction based on, again, Camacho, where there's a very clear boundary drawn around what the evidence can be used for and when it cannot be admitted.
So isn't that contradictory, though? I mean, on the one hand, you're saying she's not really limiting to the first blow and what it can be used for, but the instruction, that's exactly what she does.
Well, I think those are two different things. What evidence she allowed in as relevant to the first aggressor issue that may go beyond what was the first blow.
That the jury can't consider.
I think they can consider all of that evidence as to determining in this case who was the first aggressor, the first to use deadly force. I think it's maybe splitting hairs, but I think those are...
It's contradictory. I mean, it's like limiting instruction. If she says you can only use it for this and for any other purpose, it's not admissible. That cabins how you can use it, and so does the instruction. So that's the point, I guess, is why is that not relevant in the jury's consideration of who is the first aggressor to know about the fuller picture about what the victim in this case did, or any case does. And certainly I know that there are federal cases that say that you can, that this fuller picture is admissible on the issue of how reasonable is the reasonable reaction to
in this case. Right, and that's of course when the defendant knows about the incident.
No, it's not. There are federal cases that talk about when they don't, particularly when they don't know it's true, that it's just this is what I know of. So it's kind of almost tantamount to the same thing. You don't really know that it happened, but yet it's still important that there's an effect on you when that you can divine about how you're going to respond. Why wouldn't that be an appropriate place for us to go?
It might be. I think again when the defendant doesn't know about these prior acts, there may be circumstances unique to those particular facts that, yes, there's a relevance there, even if he didn't know the reputation is such that it is probative in some way. I don't know that that's the case here, but certainly nonetheless, again, ample, I would say, evidence admitted on that point. Again, it was essentially undisputed that the victim had a propensity for violence in this case. Did that answer your question?
If we
It
conclude,
does, as best you could, thank you.
if we conclude there's error here on this, is there so much evidence of his violence that is put in any way that doesn't matter? Because, I mean, he's threatening the victim repeatedly with pummeling and, I can't remember all the things he said, but it gets in, right?
Right.
Yeah.
You have reputational violence, you have his reputation, and you have his knowledge of past acts. You have
and
every-
then
and
the
then-
direct
and then-
threats.
And then
from-
adjutant.
And certainly, that's sort of why I think this case is a poor one for expanding adjutant, because I think that theme that the defendant urges he was hamstrung on, that the victim never backs down, ran throughout the evidence about the victim in this case. Again, all of the adjutant instances had violent episodes that were in progress when the police arrived. The threats to the defendant included,
Which might have led to the second-degree murder,
sorry?
which may have led to the verdict in this case.
Right, right. So in some ways, I think that was successful on that front. But he said, you know, I'm going to break your arms, I'm going to break your legs, I'll go easy on your back, and when you're unconscious, maybe I'll stop at that point. So he's kind of saying, I won't back down. So I think on the prejudice prong, that evidence is all in the mix.
And how about on the jury instruction, failing to be specific that adjutant applies to not just first aggressive, but first to use deadly force?
I think she was right under our case law to limit it to just deadly force, because, you know, if you're the first aggressor of non-deadly force and someone escalates, you can't respond with deadly force to non-deadly force. So the non-deadly force issue is sort of a irrelevant concern. I don't know if it's exactly irrelevant, but not the aim of what the evidence is in this case.
Yeah, but it's really not an issue of a fist fight turned into a knife fight
Right,
in this case.
right. And one point I want to follow up on that with, but I seem to have lost it, so if there are no other questions.